Hello, everybody. How are we doing? We are back for another session of our SQE MCQs straight from the SRS website to your screens through this live session. So we took a break last week because everybody needs a bit of a break. But I have to tell you, I missed you guys. Yeah, this has become such a kind of built-in feature of my. I'm sorry. It's become such a built-in feature of my routine that I actually missed it. So I was looking at the calendars and stuff, and I realized that it's been like 2 weeks now since we've had a live session, and I thought, yeah, I'm pleased that we're diligent on this, both you guys coming for these sessions and me being able to kind of deliver those sessions for you. So we will continue, I promise, along these lines in having our Wednesday lunchtime coffee sessions, so we can battle some MCQs for the SQE. How are you all getting on? I think winter is catching up with us. Is it Guy Fawkes today? The kind of bizarro celebration of some sort of attack. Yeah, this is kind of a strange thing. I never quite understood this, but yes, if you're currently in the UK, there's going to be a lot of fireworks around, because this is what people like to do around these days. It scares the cats and the dogs, and it's not particularly pleasant, but there you go. And how are we getting on with our prep? You are getting now a little bit closer to the January exam. Do we have anybody watching us live right now that is preparing for the January 26 examination? If that is you, let us know in the chat or send us some sort of sad emoji so we can all participate in your troubles together. So yes, we are, we've gotten into November, so we got like the whole, okay, well, no, I'm so sorry. Well, somebody has to do it. So Adri there says that she's online for the line for the January exam. So yes, we have to get through this somehow, and we now have got a couple of clean months of prep before we get to the point that we are actually sitting our exam in January. And what we are here to do is to support you guys in your preparation by making this a little bit more lively and a little bit more fun. Okay, did I say fun? I take this back. It's fun for me. I'm not sure it is fun for you guys. But the whole idea is that people who are preparing for the SQE are missing community and engagement. And the primary thing that I'm trying to provide through these sessions is to offer a sense of community and to let you guys know that there are other people around going through the same trouble. And if you're in a prep school, you are probably in communication with other people, or you have some sort of team or study group or something, so you know that there are others around. If, unfortunately, you do not have a prep school and you're doing this by yourselves, then this might be a very isolating experience. So my main motivation for engaging in the various live sessions that I do is to bring the community of candidates together so you can all work together and we can all support each other through this process and make it a little less painful. Now, in addition to this, there are various kind of asynchronous forums where people can meet up. I mean, I've got a Facebook group that has quite a lot of people on it that you can choose to communicate there. There's even a smaller Facebook group for the channel members that is a little bit more contained. We've got a community on Reddit as well that we can discuss there. Always we can communicate and discuss through the community forum here on YouTube. So there are a lot of opportunities for communication. But I would advise you guys to kind of leverage this because it can be a very lonesome experience overall. So the more in contact you are with other sufferers of the SQE prep, I think the easier is going to be for everybody. So, are we ready for some questions? What we're doing every Wednesday at 1 p.m. Is going through the SRA sample questions. Now, why are we looking at the SRA sample? Because they don't give us past exam papers. And because they don't give us past exam papers, we've got nothing legit to prepare with. So the closest we can get to are the sample questions that the SRA is publishing in its own website. So if you guys go to the SRA website, you're going to find sets of sample questions. Okay, the cats seem to be demolishing the place. So some are on FLK1, some are on FLK2, and they offer you the question and the possible answers, and they tell you which one the correct answer is, but they don't tell you why. And that's where we can make I can make a contribution here. We want to know not only why we have which one's the correct answer, but we want to be able to figure out why the correct answer is correct and why the wrong answer is wrong. So this is what we're doing here by going through those questions, and it gives me the opportunity to explain some stuff about the background law that each question relates to. And especially if we hit a question that's particularly difficult, or if it's an area of difficulty that normally causes trouble for candidates, we can spend a little bit more time on this. Since you guys are watching this live, if you got like any thoughts or observations or comments or questions, please put them in the chat. If you're watching this on the replay, put them in the comments under the video, and then I'll get back to them later, because I get a notification when somebody posts a comment, so I'm able to see that. So what I'm going to do now is share the screen where I have the questions, and we can start going through them together. Now, let's see. This is always a slightly fiddly process for some reason. Okay, right. The way to do it is to click on it, and then it appears as if by magic. You know, we shouldn't be complaining. YouTube gives us a lot of functionality, so on occasion something's a bit glitchy, but that's fine. Now, I said this is a coffee break, but I didn't have the chance to. I didn't have the chance to boil the water, so I'm having a soft drink instead. Okay, no, I'm not. This is not sponsored by anybody, so let's not give them any free publicity. So just generic is what we're gonna call it. Generic soft drink. And when I'm done, I'm gonna make a coffee in my favorite San Francisco mug, which I've got next to me, but it's got no coffee inside. All right, let's go. We have gotten up to question 42. If you want to see all the previous questions from question 1 all the way up to question 41, these are all in the recordings of our previous sessions. So all these are available live. They're available on the recording for everybody for free. So you can go back and watch all the questions from the beginning if you're working yourselves through this set of sample questions from the SRA. Now, question 42. A large public limited company leases a vending machine to a small village school. The school has failed to make a payment of £300 due under the lease agreement for the machine. The company has commenced a claim against the school in the county court. The school is defending the claim on the basis that the sums are not due because the vending machine no longer works. The company has instructed its solicitor to compile a list of documents containing, what's this, 267 pages of emails, and to seek expert evidence on vending machines from 2 different experts. Are these instructions likely to be consistent with the overriding objective of the civil procedure rules? Okay, so the question is about civil procedure and the civil procedure rules. What are our potential answers? So, are these instructions likely to be consistent with the overriding objective? No, because the overriding objective requires the parties to help the court deal with cases justly and at proportionate cost. B, no, because the overriding objective requires the parties to help the court deal with cases quickly. C, yes, because the overriding objective applies only to the courts, not the parties. D, yes, because the overriding objective requires proportionality only in regards to the relative merit of the claim, not in regards to the relative value of the claim. E, Yes, because the overriding objective applies only to pre-action contact. Okay, would you like to venture a guess as to which one is the correct answer? I know which one I'm voting for. What do you guys think? Do we all remember what is the overriding objective? Yeah. It is now, if you guys have not revised the civil procedure part, which is inevitably and unfortunately part of the FLK, the civil procedure rules determine what happens in the process of litigation in the courts, and the overriding objective is a sort of background expectation that informs everything that happens in civil procedure. And the aim of the overriding objective is that the justice system achieves just results when it's looking at cases in the most efficient way possible, both in terms of time and in terms of cost. This change was introduced in the new version of the civil procedure rules because of dissatisfaction about increasing costs and delays and dysfunctions within the legal system. And the reason why there were so many costs and delays and dysfunctions is because under the previous understanding of the rules, the parties were in charge of a lot of evidentiary procedures and a lot of evidentiary production processes. Now, clearly, you don't want that, because if you've got a party that is well resourced, they can actually use that to put pressure on the other party by asking multiplicities of opinions from expert witnesses, by asking for very extended disclosure of information and all of that stuff. So the aim of the court is to achieve just outcomes, but in an efficient manner, so that parties who have got differential funds to spend in the litigation don't actually attain an advantage by having more money to spend. So with this in mind, the correct answer here is A. Are these instructions likely to be consistent with the overriding objective of the civil procedure rules? The answer is no, because the overriding objective requires the parties to help the court deal with cases justly and at proportionate cost. Now, this cost would not be proportionate. This is a claim for breach of contract, right? They haven't paid £300 that were due under the lease. Now, seriously, instructing two expert witnesses and spending the solicitor's time to collate documents that contain 267 pages of emails is going to run you bills in the tens of thousands of pounds. Now, surely this is not something that is the time and the money investment suitable to a claim for £300. That's why the correct answer is A. What about the rest of them? The second one says no, because the overriding objective requires the parties to help the court deal with cases quickly. Not only. It's not about speed without context. It's about speed and cost efficiency at the same time in achieving a just outcome. So B is wrong because it doesn't take the totality of the overriding objective in mind. C says yes, because the overriding objective applies only to the courts, not the parties. No, this is wrong. The overriding objective applies to the totality of the litigation experience and guides everybody. D says yes, because D says yes, because the overriding objective requires proportionality only in regards to the relative merit of claim. No, it doesn't. Okay, it's about the whole process. And E says yes, because the overriding objective applies only to pre-action contact. No, that is wrong as well. It applies to everything at every stage of the litigation process. There we go. So if you guys want more information on this, I've got a couple of nice videos on the civil litigation process and where I explain the overriding objective and all that stuff. You can find them. Now, incidentally, I'm preparing a whole new series where I've got videos that are tailored precisely to the FLK. Because even though I've got videos on the channel already that cover the totality of FLK1 and FLK2, maybe they're a little bit difficult to navigate because I was going through them thinking about the topic, but not thinking necessarily about the SRA's specification. So I thought I will rework this material, update it for the exam in 2026, but arrange the material precisely in the way that the SRA lays out the requirements for the FLK. So you're finding now new videos. I've got a new playlist that's called Preparing for 2026, and these videos are placed in there. I've got all these new videos that you can map the information that I'm giving you exactly against the SRA specification, which hopefully makes things a lot easier for you guys to access. Now, all these videos, the moment that I have them ready and they're uploaded on the site, they are immediately available to channel members. So if you want to join the channel for the price of less than a coffee, for the price of a Coke actually, of $2.99 a month, you can see all these videos straight away. If you don't want to do this, which is perfectly fine, and you want to wait a little bit, all these videos are on a schedule of publication and are gradually coming available for everybody for free. Every week they publish every Saturday. So all these new videos precisely on the SRA specification. Either you become paying members of the channel, and you can see them all immediately, or you just wait for them and you'll see them every Saturday. And I think they will be a good contribution to your preparation, especially if you guys are kind of gearing up your capacity for the examination in 2026. Are we ready to move on to our next question, which is going to be question 43? How are you guys doing so far? Are you... Do not panic. I think the questions we've got for today are a little bit easier than usual, so it should make everybody feel a little bit better. Throw me an emoji that represents your emotional state. Adri there already gave us like a crying emoji, so I'm guessing that's the emotional state. How about the rest of you? Hit an emoji button there and let me know how you feel. And you can do this. You don't have to do this now. You can do this as well if you're watching this on the replay. Yeah. Okay. Question 43. A debtor owes an unsecured creditor £5,000 due to be repaid today. The debtor tells the creditor that they can only repay £4,000 and asks that the creditor agree to this being in full and final settlement of the whole amount. Fearing that the debtor, who also has other unsecured creditors, is about to be made bankrupt, the creditor agrees. Question: can the creditor enforce the payment of the remaining £1,000? Your options are yes, because the agreement to accept less than the full amount was extracted under duress. B, yes, because the debtor provided no consideration in return for the agreement to accept less than the full amount. C, no, because the creditor has waived entitlement to claim the full amount. D, no, because the creditor obtained a legal benefit in receiving £4,000 rather than nothing. E, no, because the creditor obtained a practical benefit of receiving £4,000 rather than nothing. Okay, now this, ladies and gentlemen, is a question close to my heart, because it deals both with issues about bankruptcy and insolvency and all of that stuff, but crucially, it has to do with concepts of contractual modification and what we understand consideration to be, especially in the area of part payment of debt. So if you have done an undergraduate law degree, when you were doing contract law, you're very likely to have come across the concept of part payment of debt. So this is precisely what this is on. Now, is it okay to give a lesser amount in full satisfaction of a higher amount? Can then this agreement to modify the deal and pay less, can it be considered an acceptable modification of the contract that extinguishes the other party from any further obligation? If that's the case, you can pay less than the full amount and have it all finished. If this is not okay, they can come after you for the remaining amount. What do you think the answer is? Who would like to venture a guess in the chat? Let me know how you feel about it. Because I've got strong feelings about this, and I'm gonna tell you in a moment. Yeah. So the correct answer here is, perhaps surprisingly, B. Can the creditor enforce the payment of the remaining £1,000? Yes, because the debtor provided no consideration in return for the agreement to accept less than the full amount. Let me explain what's going on here. Consideration is the concept of value that supports a contract. Both parties are promising to do something that is valuable for the other. Each party promises to do something that's valuable for the other. Remember that I'm talking about promises, right? It's not the actual performance of the thing. They don't have to do it there and then. They just have to promise something that the other party considers to be valuable. When you're having a contract for the first time, like, I'll sell you this phone for £100. I'm promising to give you the phone. You're promising to give me the £100. Therefore, we've got consideration on both sides, and the contract is fine in that regard. If after a while you turned around and said, actually, you know what? I don't have £100. I've got £80. Is it okay if we change this contract and I give you £80 for the phone? Here we've got a problem, because now we're discussing a modification of the contract. But in order for this modification of the contract to be supported by consideration, we need to have, again, a promise of value that is different from the original promise. And this needs to be on both sides. If I'm still giving you the same phone, but now you're promising a lesser amount of money, you are doing something different, but I'm not. Therefore, the contract is unbalanced and the modification is not valid. If this went to court, the court would say that the modification fails because there is no new consideration. If I changed something at my end as well, and I was like, okay, you know what? Fine. You don't have £100. I'm gonna give you the phone, but I'm gonna keep the memory card because I paid like £20 for the memory card. So if you cannot pay 100, I'm not giving you the memory card. Are you okay with this? Yes. What has happened then? The original deal was phone with a memory card for £100. Yeah. Now the modified agreement is less money, £80, but you're getting something lesser for me. You're getting something different for me. You're getting the phone without the memory card. So it balances again at a different level. This is what we need in order to find consideration to support the contractual modification. In the scenario that is given to us by the SRA question number 43 here, a lesser amount of money is offered in satisfaction of the full debt. How does this balance? It doesn't, because it's an attempt at a contractual modification, but one party is still expecting the full amount. The other party is promising less. These guys are not getting anything. In order to have this valid and balanced, something different needs to happen on both ends. So this guy might say, oh, I'm going to give you less money, right? Because I cannot afford it. But I'm going to pay you quicker than before. So something has changed here, something has changed here. And the thing balances out again. If the change is only on the one side, then it remains unbalanced. Therefore, it is not supported by a consideration. The modification is not valid. The original obligation persists, so the creditor can enforce the payment of the remaining £1,000. Is there anything else that we could think here that might change the situation? Could we have a discussion of promissory estoppel? You guys remember promissory estoppel? Is the concept that if a promise has been made and the other party has relied on that promise, and it would be unfair in the circumstances to take the promise back, then the contractual obligations are still there, but they cannot be relied on because it would be unfair to the other party. That's how promissory estoppel is meant to work. Can we use promissory estoppel in a situation of part payment of debt? No, we cannot. And we've got a lot of case law backing this up, going back, from like a long time ago up until more recently. You cannot use promissory estoppel in part payment of debt situations. If you could do this, nobody would repay their debts because everybody could use hardship as the reason to say it would be unfair to pay the whole amount. If you're thinking about all this, you might think, but wait a second, how can we have settlements then? You know, if you owe money to somebody and you haven't paid, then they probably sell the money to a debt collector. And then the debt collector comes after you and makes you a deal. So how is the deal from the debt collector enforceable while a deal to pay less with the original party wouldn't be? This goes back to what I said originally. Has something else changed? Is it that you're paying less money, but now you're paying in an installment schedule that they proposed? Is it that you're paying less money, but you're paying quicker? Is it that you're paying less money in addition to something else? So long as something has changed on both sides, then it is fine. Or it could be done by deed. You guys know what that is, right? A deed is a formal witnessed document, which then means you do not need consideration to make an obligation enforceable. So the reason why we have settlements for money obligations is that either they're made by deed or because you're offered something as part of the settlement that kind of balances the deal on both sides and there is new consideration to support the new promises. If we stay with the original proposition here that the only thing that changes is the part payment of debt by the debtor, then this in traditional contract law technical terms would not be enforceable and would fail. So the correct answer here, can the creditor enforce the payment of the remaining £1,000? Yes, they can, because the debtor provided no consideration in return for the agreement to accept less than the full amount. Why are the remaining questions wrong? The first one says, yes, because the agreement to accept less than the full amount was extracted under duress. We have no evidence of this in the case scenario. This might be true, but this isn't what's going on here because the question doesn't tell us this. C says, no, because the creditor has waived entitlement to claim the full amount. There is no indication that I have actually waived entitlement to the full amount. So this is factually not supported by what the question says. D says no, because the creditor obtained a legal benefit in receiving 4,000 rather than nothing. No, that doesn't work, okay? Because this would be the case always. And E is wrong for the same reason, because it hints on this idea of practical benefit. You guys remember the idea of practical benefit consideration? If you don't, I've got like a couple of videos explaining the doctrine of consideration. You should go through those and you'll see there in more detail. You'll always receive a practical benefit by having some money rather than nothing. If this was an excuse to validate unilateral decisions to partly pay debts, nobody would pay their debts anymore, right? So, because it's kind of self-evident that it's better to get something rather than run the risk of getting nothing. So, the only correct answer here within the context that the question is set is question B. Now, having said that, I need to remind you guys that this is an artificial exercise. The MCQs that we're attempting for the SQE are structured in a particular way. What we're looking for is not one complete, fantastic, absolute answer, and then the others are going to be totally wrong or irrelevant. What we have is a gradient of potential answers that might go some way towards answering what the question is asking. Your job is not to pick the one super correct one against all the other ones that are garbage. Your job is to pick the one that comes the closest. And for that reason, you need to adjust your expectations. Do not expect to find the one perfect, 100% absolute answer. You are meant to find the one that is the better fit, even though it is not perfect. So if you think about it in that way, it takes away a little bit of the anxiety that you might be suffering by thinking, how can this be the correct answer? It just seems to be incomplete. Because you're not looking for perfection. You're looking for the closest possible fit. So try and remember this. in every question, you're going to be given a scenario that's like another chunky paragraph, and then you're going to have 5 potential answers. Out of those 5 potential answers, one is the one that gets the closest. You're going to have a couple that are close but not quite there, and you're going to have another 2 that kind of are wrong either factually or in terms of the law, right? Your job is to pick the one that comes the closest. Do this quickly, move on to the next one. You got less than 2 minutes per question. You cannot linger, so make a decision, pick the closest match, move to the next one, on you go, right? Hopefully this makes sense for you guys. If you find all that stuff helpful, hit the like button so more people get notified of these coffee breaks and they come and join us next time. Yes, because YouTube understands these things by, like, if people comment, if people say something, people hit the like button, then this must be a good experience and they tell everybody else. So if you're finding this a viable experience, hit that like button so we tell everybody else. Okay, now, what do we do now? Shall we move on to our next question, which is going to be number 44. Let me see where we're at. Question number 44. All right, good stuff. A driver drives negligently, and as a result of which he has an accident. A passenger in the car is hurt in the accident. The passenger had a serious pre-existing back condition of which the driver is aware. The condition is exacerbated by the accident and the passenger becomes paralyzed. Which of the following statements best describes whether the passenger can claim damages for his paralysis from the driver? Is it A, the passenger can claim damages for his paralysis from the driver because the paralysis was in the contemplation of the parties as possible at the time of the accident? Is it B, the passenger can claim damages for his paralysis from the driver because the driver must take the passenger as he finds him? Is it C, the passenger cannot claim damages for the paralysis because it was not reasonably foreseeable that paralysis would result from the accident? D, the passenger cannot claim damages for his paralysis from the driver because the paralysis did not result from the accident in the normal course of events? Is it E, the passenger cannot claim damages for his paralysis from the driver because the passenger is partially responsible for the paralysis because of his pre-existing condition? Okay, so we are in the domain of the law of tort. I had a nice I've got a nice updated tort lecture that just came out this Saturday. So you guys can have a look at that one. It starts with a rather shocking take on buying. I'm not going to tell you what, I'm not going to spoil the surprise. I'm not going to tell you what it is. But it starts with a little story of somebody who's ordering a coffee at their favorite coffee shop and something horribly wrong has gone with the coffee. So try and go and watch that video and then tell me how grossed out you are. Okay, so law of tort, we're thinking about causation, we're thinking about remoteness. Normally, to hold somebody responsible for the consequences of a breach of duty of care, the consequences need to be causally related, and they need to be, in terms of remoteness, close enough to, or at least legally related to what the breach of the duty was about. So how do we deal with this situation where somebody might be weaker than expected or weaker than the normal person would expect and suffers worse results out of the breach of duty? Now, clearly, we're not debating the commission of the tort here, because if a driver is by law burdened with the duty of care towards passengers of the vehicle and other road users. So if we have a situation where a driver drives negligently and causes an accident, then this is the commission of a tort, and then any injuries that happened to people around or damage to property needs to be compensated as arising from this breach of duty. But should we consider the person's pre-existing weakness as something that breaches causation or something that places this beyond the realm of what should be compensable for this breach of duty? If you got an inclination on what the correct answer might be, now is going to be the time to put it in the chat, because I am about to give you the answer. Okay, you guys are too timid today. What's up? We got a lot of people watching us live, which is absolutely awesome, and thank you guys. But you're not putting your opinions in the chat. We're not gonna judge you, okay? So if you're feeling inhibited, thinking that you're gonna get heckled by the other candidates if you get the wrong answer, don't, okay? So this is your safe place. This isn't the SQE itself, okay? You can make mistakes on kind of guessing what the answer is, and nobody's gonna come after you, yeah? Unless, of course, unless you're actually students of mine who have studied with me, who ought to know all this stuff already, then I'm gonna judge you. But I don't know who you are, so probably not my fault if you get it wrong. Okay, what's the correct answer to question 44? The correct answer, ladies and gentlemen, is B. The passenger can claim damages for his paralysis from the driver because the driver must take the passenger as he finds him. Why? This is known as the egg-shell skull rule. Let me say it again. Egg-shell skull rule. What this means is, if I cannot tap you on the head because you're annoying and your skull is as thin as the shell of an egg and it cracks and you get yourself injured, then it's my fault. I cannot say, oh, I was just being silly and I just kind of tapped you one, and the fact that this caused serious injury has got nothing to do with me. How should I know that you got a problem in your head? No. Cases like Smith versus Leach Brain from 1962 established this, that say the perpetrator of the tort takes the victim as they find them. So you're not expected to have known about pre-existing conditions and weaknesses and so on, but it doesn't matter. You cannot absolve yourself of the responsibility because of the particular characteristics of the victim if you're responsible for the breach of the duty of care. Teresa there has put her suggestion as B. Thank you, Teresa. And it is correct. It is in fact B. Why are the other suggestions wrong? A says that the passenger can claim damages because the paralysis was in the contemplation of the parties. This is not necessary, right? This would be the remoteness requirement for breach of contract for losses that do not arise naturally out of the breach. It's a tort case that we're talking about here. The contractual understanding of remoteness is not necessary. C, the passenger cannot claim damages because it was not reasonably foreseeable. Again, same problem. We don't take the contractual understanding of the doctrine of remoteness and apply it to tort situations. D says the passenger cannot claim damages because it did not result from the accident. Right, hang on here. If it did not result from the accident, it would be a breach in the chain of causation. So in that case, yeah, that would be true. If what the accident has been caused by something that is unrelated to the car accident, then you're not going to hold the driver responsible. But this is wrong here because it does not conform with the facts as stated in the scenario. You remember what I told you before? Some questions are going to be wrong because they misstate the law. Some answers are going to be wrong because they misinterpret the facts, right? So in choosing the closest possible answer to what the question is asking, you need to think both about it matching the facts of the problem question that you're given and stating the law correctly. D is wrong because it misrepresents the facts. E says the passenger cannot claim damages because the passenger is partially responsible. This is taking you down the route of contributory negligence. Contributory negligence is through action, is not through characteristics, okay? So you cannot be contributory negligent simply by existing or having a disability or having some sort of weakness or having some particular characteristic. Contributory negligence can only happen if you have committed an action that is negligent, that makes your situation worse. Here, the poor person didn't do anything. They just happened to be more susceptible to the damage than the average person. So, correct answer to this one, ladies and gentlemen, is B. Swiftly moving on to question 45. Where is that? Question 45. Okay. Now, in 45, a woman owns shares in a private limited company. The shares are not in an ISA. In the 24-25 tax year, the woman receives a dividend of £5,000. Her only other source of income is her salary, and her taxable income, including the dividend, is £41,000. In 24-25, the personal allowance is £12,570, which is with a basic rate tax band between that amount and £50,270. The dividend allowance, thank you very much, government, is only £500. How much income tax, if any, should the woman pay on the dividend? Okay, so we've got a taxation question. I don't know how you guys feel about taxation questions, but they tend to make people feel a little bit uncomfortable because the majority of lawyers are absolutely terrible in counting numbers. I don't know. Give me a distressed emoji if that is you. Because most of the people that I know that get into law, they get into law because they have to count with their fingers, right? That's how they dropped out of all their science classes. But anyway, maybe that's just me. Now, what are our options here in calculating income tax? So, how much income tax, if any, should the woman pay on the dividend? Option A says none, because the dividend was paid by a private limited company whose payment of corporation tax on its distribution of profits satisfies the woman's liability. B, none, because her taxable income, including the dividend, does not exceed the upper threshold for the basic rate tax. C says she should pay income tax at the income tax basic rate for the entire dividend because it exceeds the annual dividend allowance. D says she should pay income tax at the appropriate dividend tax rate on the proportion of the dividend that exceeds her annual dividend allowance. And E says she should pay income tax at the income tax additional rate on the proportion of the dividend that exceeds her annual dividend allowance. If you guys haven't experienced this through your own personal tax situation, and if you haven't studied these bits and bobs about income tax and taxation, you are likely to struggle with this one. Yep. So what would you pick as the correct answer here? This is the most difficult question on the set for today, I think simply on account of unfamiliarity with the territory. Yeah. Right. I am going to give you the answer. The correct answer is D. The lady here should pay income tax at the appropriate dividend tax rate on the proportion of the dividend that exceeds her annual dividend allowance. Why? Because dividend income has its own tax rates, and you get a dividend, you get free, tax-free dividend payments, yeah, up to the level specified by the government. This dividend allowance, as it's called, it's given to you by the question, is £500. So if you get £500 paid as dividends from a company in which you own shares, you are not liable for any dividend tax on that one because you're still in the tax-free domain. This does not mean that your overall tax situation doesn't change, because you receive this as income, so it's added to all your other income, meaning that your total income has now increased. So it could be that you lose, say, some benefits, or you lose your child benefit, or you lose something else, or it puts you in a higher tax band altogether for your overall income tax because now you've earned more. But so far as the £500 themselves, these are not taxable because they are still within the dividend allowance. I know about this. So I could talk all day, but you don't want me to, okay? It used to be £1,000. Now it's 500. I bet they're going to take it out completely. Now, on the other hand, this is like rich people problems, okay? So there's worse things in the world than paying some tax on your dividend income. But hey, so correct answer is D. What is wrong with the others? A says none because the dividend blah blah blah. This is completely wrong, guys. Completely wrong. This is shockingly wrong, because this A confuses personal with corporate taxation, and on who gets it. Like the whole thing is garbage. B says none because your taxable income does not exceed the upper threshold. This is also wrong. This doesn't mean anything. This isn't how this works. Okay. C says she should pay income tax at the income tax basic rate on the entire dividend. No, because the rate is not your income tax rate for dividends. They've got their own special rates that are lower than your traditional income tax rates. So that's C. Why is E wrong? Because it says she should pay income tax at the income tax additional rate. Again, this isn't the correct rate for taxing dividends. So all the potential answers other than D are wrong. The thing is to figure out why they're wrong, so you prepare yourselves adequately if you're expecting similar questions to come up. Did you find this question difficult, or is this an area of the law that you guys are feeling more comfortable with? I mean, as I said, from my experience in what we're doing with candidates, I don't think people are super comfortable with the tax stuff. So be a little bit wary about this. They have enough questions in the SQE to ask you about everything. So they will inevitably stick some questions in there about unpleasant stuff like inheritance tax and income tax and investment earnings and all of that stuff. They will, okay? So be careful with it. I've got some videos that discuss the basics of taxation, both on a corporate and on a personal level, but I think because we need some more material on this, I'm preparing some new videos for 2026 that are going to go into these areas in a little bit more detail to help you guys out. Are we ready for our last question of the day, which is going to be question 46? Okay, question 46. A solicitor is employed by a firm of solicitors that is regulated by the SRA. Yay! This firm is an exempt professional firm for the purposes of financial services. The firm is not authorized by the FCA. The solicitor is acting for a woman who is considering buying one of two neighboring plots of farmland. The woman would like advice on which of the two plots she should purchase, and the solicitor refers the woman to a chartered surveyor who is linked or tied to a particular land agent. The woman makes her selection and decides to proceed with the purchase of one plot of land on the basis of the advice she receives from the chartered surveyor. Neither the solicitor nor the firm receive a commission or other benefit as a result of referring the woman to the surveyor. The firm and the solicitor comply at all times with the SRA rules and the SRA financial services rules. Which of the following statements best describes why the solicitor is not in breach of the general prohibition under Section 19 of the Financial Services and Markets Act of 2000? Is it A, the plot of land is not a specified investment? Is it B, the solicitor is not acting in the course of business? Is it C, the solicitor can take advantage of the authorized third-party exclusion? Is it D, the solicitor can take advantage of the introducing exclusion? Is it E, the solicitor's advice is exempt as the firm is regulated by the SRA? What do you think the correct answer is? The whole thing here is about the rules of solicitors in relation to ethics and professional conduct. This is not a separate category, but it is examined throughout the FLK. So you might come across questions on ethics and professional conduct, either in FLK1 or FLK2, and they're kind of intermingled with everything else that you study. I mean, clearly, when you're preparing, we do have specific lectures, there are textbooks and stuff like that that discuss ethics and professional conduct, but the way in which they're treated in the examination is by folding them into other areas as you go along. So what would you say is the correct answer here? I am going to give the answer. The answer is A. The plot of land is not a specified investment. It does not fall within the general prohibition of Section 19 of the Financial Services and Markets Act of 2000. Section 19 is saying that one cannot provide advice on specified investments unless specifically authorized by the regulator. If it doesn't fall within specified investment, then this is not the correct tool to regulate that advice. Purchase of property, purchase of land, or purchase of buildings, or anything like this is not one of the specified investments. The coverage of this is various types of financial investments. So as the plot of land is not a specified investment, then the solicitors have got no obligations under Section 19. This is why all the other options are wrong. So whether they are acting in the course of business, but whether they can take advantage of specific exclusions is irrelevant because they don't need an exclusion under Section 19 because what they do is not covered. So that's it. Yeah. So you only have one potential correct answer here, which kind of eliminates the need to look at anything else because under Section 19, this plot of land is not a specific investment. Okay, so how do you guys feel about all this today? I'm very pleased that we've come back. I'm pleased that we managed to meet and enjoy our coffee break together. What I would like you guys to do is to have this mental association of a coffee break with an MCQ. Right? Every time, I know this is going to be obsessive, like this is going to dominate your lives. Every time you're kind of holding a mug in your hand or you're kind of walking out of Starbucks, you're going to think, damn, I should be doing an MCQ right now. This is what Yannis said. So if you're looking for more opportunities to do MCQs, you should subscribe to my newsletter. You can do this by emailing newsletter@glintis.co.uk. I put it in the chat for you guys. And every Monday, I'm going to send you a fresh multiple choice question to attempt. I will also give you reading material and advice and tips and tricks and discount codes and kind of purchase suggestions that are going to help you with your preparation. And I'm going to give you a fully articulated answer to the previous week's question. So in a similar way to what we do here, I will explain why the correct answer is wrong and the other way around. Why the correct answer is correct and why the wrong answers are wrong. Because if the correct answer is wrong, that doesn't help, right? And you get all this for free simply by emailing newsletter@glintis.co.uk with the word subscribed in the subject matter, and I will add you to my mailing list. Now, other than that, there are the occasional opportunities for us to meet together in a smaller group. I'm running some members-only session, members-only live streams for people who are paying members of the channel. So as I said, this is only $2.99 a month, so you guys can try this out for a month to see if it works for you. You're getting these special sessions. You're also getting an advanced view of all the videos that are getting listed and all of that stuff. And next week, I think we're still good. Yes, next week, 1 o'clock on Wednesday. Again, we're going to meet again and go through some more SQE questions from the SRA's sample. So, guys, thanks so much for joining me today. I had fun. I hope you enjoyed this. If you did, tell your friends so everybody can join in and we can have more candidates. We can that can participate in our community next week. It was great to see you, so many of you live. Thank you, and I'll see you next week.